I guess, because that's okay. They just went by what was posted on Kiwi Farms. They lied and said they were a private investigator, and then they said that, and they decided to put in a footnote, this girl was a minor, which has no bearing on it.
Just some fucking Dota, man.
Not only is plaintiff's allegation knowingly and demonstrably false, but also the age of the purported recipient of the video is irrelevant to plaintiff's claims, and has no bearing whatsoever on whether this court has subject matter jurisdiction here.
Why?
They managed to, well, not they, but somebody in Justicle's Discord server threatened the victim and her family across multiple email accounts. All of Justicle's Discord server knows this. They laugh about it. I think I've shown pictures of that. It's I think the sabasexual dude, but basically harassed them and threatened the family until they contacted Joan Peters in order to sit for a deposition. Unfortunately, that deposition was a fucking train wreck for the subhuman Phil Pixie and her counsel. And what we find out during the deposition is that this person never was in charge of any of the accounts that they'd ever been posted publicly online. So the Twitter account, any Cash App account, the Discord account that apparently I was talking to for 2 or 3 years was actually ran by another guy who you should be able to understand how unbelievably fucked everything is related to this other dude. But so that comes out in the deposition. I think about halfway through the deposition, Pixie and Joan basically just start accusing the girl of lying because that's all they can do at this point, because now they've lost completely on their subject matter jurisdiction related to the video transfer date for this person, because the international sex trafficker dude is in the UK, so that explains the timestamps. And then the fact that I've never had a conversation apparently with this girl means that their footnote is also incorrect, which should have never been there in the first place. And so obviously after the deposition, we made a request from them, like, hey, can you file a correction on this? Because you kind of just like sticking this in public filings. I think they don't respond maybe for like a week. And then we said, hey, why don't you, what do we say? Oh, we basically said, if you don't do this, we're going to file a Rule 11 sanctions against you. And then they said, well, if you file a Rule 11 against us, we're going to file a Rule 11 against you. Apparently I know that it mind fucks some people. You could get something wrong from 2 or 3 years ago. I know that in the court of Justicle's Discord server's opinion in Kiwi Farms, that if somebody says something at some point in time, you can use one message to try to win an entire court case. There's a reason why this case is dead. There's a reason why none of that is true. And I know that it's fun online to try to have like one message, like, well, you said this one thing, so it must mean all blah, 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 blah. But unfortunately, that's not how the big boy world works. And you have to actually like build a case using real evidence and not a single sentence or a single statement. Keep in mind that at the time I'm talking to Pixie on this thing, remembering my conversations with this girl, or supposedly the girl, but I guess there was some creepy fucking weirdo on this account the entire time. I am standing in the shower, getting notified that 27 plus videos or whatever may have been posted online. The majority of them are just fucking single solo masturbation videos of me. So sorry if my memory recollection wasn't absolutely flawless or perfect at that particular point in time. But I know that you love the single messages because it's literally all you people have. So knock yourself out. Single messages. The record is the record. Get fucked. Knock yourself out. As an initial matter, plaintiff and her counsel have been on notice of the falsity of their allegations since at least October 23rd, 2025, the date of the person's deposition. At the deposition, she testified to a bunch of things. Rather, she also testified a whole bunch of other things. Bonnell did not share any sexually explicit material with. This is the Rose account, or the Rose person, the underlying person, or any other minor. In light of this testimony, Bonnell demanded the plaintiff file a notice of errata and corrected opposition without the false and defamatory allegation included therein. Despite this demand, plaintiff and her counsel have failed and/or refused to do so in violation of their obligations under Rule 11. The court should impose appropriate sanctions. I think Rule 11 just has to do with like filing things that I think Rule 11 just has to do with like making sure the stuff that you file with the court is truthful. Destin, you said they were fairly close to you, to Pixie too, because this was a person who I thought was fairly close to me. I had 2 or 3 years of conversations with this person. Yes. Yes. Factual background on September 19th, 2025, Bonnell filed a motion to dismiss the operative complaint on the grounds that the court lacks subject matter jurisdiction.
Go on now.
The alleged transmission of the video preceded the effective date of the federal statute, which forms the basis of the plaintiff's complaint. Pixie knew this from the very beginning as well. Maybe more will come out about this, maybe not, but basically, I can say with 100% certainty that Pixie and Lauren have been collaborating to hide and obscure evidence. When I keep complaining publicly, they're not giving me discovery. She's not giving me discovery. She's not giving me discovery. That's bullshit, and I'm lying to you. I know why they're not giving me discovery. It's because the both of them have collaborated on destroying stuff so that they have nothing to turn over to me. That's what I really meant when I was saying that. But that's what's been going on the entire time. That's why I said I'm going after Lauren's legal license as soon as this case is over. I'm going to be trying to file the mother of all fucking bar complaints in Florida to get her disbarred. And then Pixie, if she ever tries to do character and fitness or whatever, for whatever bullshit, dog ass law school she's going to, it'll be the same fucking thing. On October 3rd, plaintiff filed an opposition to the motion. In the opposition, plaintiff falsely asserted the Bonnell exchange sexually explicit material with minors, specifically in a wholly irrelevant footnote. Plaintiff falsely stated,
this isn't the fucking
after
lawsuit.
ascertaining Rose's legal identity, plaintiff has obtained evidence that Rose's date of birth is October 30th, 2004. Thus, when Bonnell was exchanging pornographic content with Rose between March of 2022 and until October 30th of 2022, Rose was a minor.
Jesus.
The footnote that they put in this filing. To support her basis claim, plaintiff identified Blank as the individual referred to in her pleadings as Rose, and to demonstrate that Ms. Blank was a minor at the time of events alleged, plaintiff filed a copy of Ms. Blank's official certification of Department of Motor Vehicles driving record, Exhibit B, to the opposition. On October 23rd, plaintiff deposed Rose in Rockford, Illinois. At her deposition, Rose testified to a bunch of things. Basically, this is more or less that I've never communicated with this person ever in my entire fucking life, which was a mindfuck to me. But
is this the Pixie one then?
Do her lawyers not realize how absolutely unhinged and unprofessional they look? To be honest, I'm surprised the judge hasn't come out yet and said you guys need to, who knows? We'll see when the rulings come out. I mean, there's still a non-zero chance. I just wanted the motion to dismiss, but they don't care about looking unhinged or not. This is a purely 1 trillion%. Just look at whatever people say about me and know that it's probably just about them. This is just a spite-driven endeavor where Pixie and Lauren are doing everything they can to cover for an actual international fucking child porn producing sex trafficker because they just want to keep hitting my reputation. That's the only thing this is at this point. But
Jesus Christ.
Bonnell did not share any pornographic content with Ms. Blank or any other minor. Plaintiff and her attorneys know this now. On October 30th, 2025, counsel with Bonnell sent a letter to plaintiff's counsel demanding the plaintiff file a notice of errata and corrected pleading to
This is
retract plaintiff's notice of false
his
allegation in her opposition.
way of
To date, plaintiff's
saying
counsel
this.
has not provided a substantive response to the letter, nor have they taken the corrective action requested. Rule 11 of the Federal Rules of Civil Procedure provides, in pertinent part, by blah, 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 so it's just all this. You can't lie in your shit. Here, plaintiff's false allegation that Bonnell exchanged pornographic material with a minor was included for an improper purpose, namely to publicly humiliate and harass Bonnell and sway the court's opinion of him. Critically, the age of the purported recipient of the victim, or I'm sorry, of the video, has no bearing whatsoever on plaintiff's claim of this action, nor does it have any bearing on whether the court has subject matter jurisdiction in this case, which is the threshold issue sub judice. Judice? Moreover, plaintiff and her lawyers have been on notice of the falsity of their allegations since at least October 23rd, 2025, yet they have failed and or refused to correct their knowingly false and unsupported contention in the opposition. Plaintiff and her counsel's refusal to correct this egregious and intentionally inflammatory misstatement warrants Rule 11 sanctions. Would you prefer not to win on the motion to dismiss? You can get subpoena info from Lauren for her No, I'm never getting anything via subpoena from Lauren. Her and Pixie have been maliciously and intentionally covering their trail and doing stuff to make sure that nothing will ever be produced from her that will be incriminating. This has been in place since the very start of these proceedings. So it doesn't matter if anything happens court-wise or any of that. It literally doesn't matter. Yeah. For the reasons stated herein, Bonnell respectfully requests that the court sanction plaintiff and her counsel jointly and severally? Severely? This is a legal term. Pursuant to Rule 11, including but not limited to awarding monetary sanction. Okay.
Woo. What you doing, handsome?
This is a declaration from my lawyer. This is a transcript from the deposition. This is under seal until, I don't know if this technically ever gets unsealed or not, I don't know. This is our email that we sent to them saying, hey, you should correct this because this is not true. This was sent on October 30th. Oh, you have to give them a notice before you file a Rule 11, I think of 3 weeks before you can file it.
Done.
I don't even know if they responded to this, other than to say that they were going to file a Rule 11 against us if we file a Rule 11 against them, which I don't even think you can do. I don't know if that's...
Bro, something's wrong with my fucking Stellaris, man.
Wait, I saying they didn't respond to the Rule 11 sanction request in the 3 weeks? I think they just said that if we file one, they'll file one. That was it. So I'll get to Jones' motion soon. I got a lot of stuff to post about this guy later as well. So Esports Batman is one of the only fake lawyers left in Just Bill's Discord server that likes to poke holes in this. I just want to say that a few weeks ago, I laughed about the fact that people were like, how could any of this possibly be true? Like, it seems so unbelievable. True, thank you. I agree. It does seem really unbelievable, which is one of the reasons why it was such a mindfuck. So, like Joan Peters and Pixie, they have switched gears into saying that, oh, well, the other girl must just be lying about everything because there's no way that any of that can be true. If that's the road that you want to go down, then feel free to do whatever you want. Remember, no matter what happens, I have to be the devil. Literally, every horrible thing in the universe must originate with me, and if anything else seems to say otherwise, that thing must be lying. But I thought she was impersonated. How does she know exactly what happened if someone else was acting as her? I'm not saying she's lying. Just she can't know everything if someone is impersonating her. You can't have someone testify to personal knowledge if they weren't there / involved with the event. So the person who was operating the account, who was catfishing me with her stuff. So this is a common thing that these fucking retards keep bringing up. It's like, oh, well then, how did you get, tell me then, Destiny, how is it that she's wearing your fucking merch? Haha. Because this guy ordered it, sent it to her house, had her take pictures of it, and then posted those pictures of her in my merchandise to me on the catfished account. This person went way the fuck beyond to try to mindfuck and catfish me and make me, to ensure that I really thought this person was who I was talking to. So yes, if you think it's incredibly fucking crazy and unlikely and weird and whatever, yes, welcome to my fucking life. But you also could just accuse, the actual victim of all of this as just somebody who's lying over and over again with absolutely no evidence. But yeah. Anyway, that was our filing on December 1st. We have 3 new filings from plaintiff filed today. Oh boy. Did he order it from your store? Wouldn't you have his payment details then? Yeah, I would. The issue is that all of my legal work initially was going to be plaintiff work. Also, ignore everything I'm saying because apparently I'm lying about all of this, despite the fact that multiple people have seen this packet that I was putting together, but everybody says I'm lying about this on Discord server because that's fine because these people are all subhuman. But the initial firm that I was working for in New York was going to be plaintiff work to go against the person who leaked everything. As soon as the defense work started, the plaintiff case took not a backseat. I axed it because I can't afford psychologically or monetarily to run 2 huge lawsuits at the same time. Okay, so theoretically, the payment information would be available from the person who initially the merch was sold to. That was a road that I was going down. But in order to get the information from them, their legal team won't release it to me because it includes addresses and everything else without a subpoena. And since I didn't file that lawsuit yet for the New York case, because we weren't ready to file that lawsuit yet, I didn't have anything there that I could use to do legal pressure against them. So, yeah. All right, number 1. Plaintiff Jane Doe's motion to modify the scheduling order. Plaintiff Jane Doe, by and through the Anderson Council, and pursuant to federal rules, blah, 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 hereby moves the day for modifying the scheduling order. So this is her begging to kick back discovery, despite the fact that they found nothing, produced nothing, and done nothing so far, and have operated in the most bad faith manner possible, including but not limiting to fabricating a person like Abby, who is clearly like fucking mentally ill or has brain injury, to get a statement from her and then refuse to produce her for any deposition. Have not sat her for deposition at all. We've got no statements, no evidence, nothing from her. They simply got a piece of paper the night before our evidentiary hearing, and then off into the wind she fucking disappears. Despite the fact that initially they said they fully represented her, and then apparently they changed their mind on that, and then they said they represented her for matters of the subpoena, and then they changed their mind on being able to provide us information about that. So they literally just stuck a fucking post-it note on this girl's mentally fucked brain, and then sent her out into the wind so that they could keep the case long enough for whatever the fuck we're at now. There is no excuse and no reason why they couldn't have sat any of these people for deposition, why they couldn't have filed anything earlier for Melina or anybody else, but because they've dragged their feet on everything, because it's not even they drag their feet on everything, they just have nothing, and they know they have nothing, and they know that nothing will come up. But now they want to move back. Discovery was supposed to end in 2 weeks. Do you know who Solo is now? I know everything now. But it doesn't matter until this court case is over. Discovery was supposed to end on December 16th. This was supposed to be the thing that I was like petrified and terrified of because apparently I was hiding so much stuff. But alas, it has been plaintiff who has been engaged in a rampant deletion of and obscuring of and hiding of materials while she continues to send me a whole bunch of irrelevant random stupid shit while she visits her fake wife that she has in fucking Miami that she illegally married to get a green card. I know for a fact that this is exactly what she did because Lauren De Laguna also helped facilitate this. All of this is 100% fucking true. She can sue me if she doesn't like it because truth is an absolute defense of defamation, and I know how litigious she is, so knock yourself out. Like I said, this is all stuff I'm going to be fucking going on hardcore after this fucking case ends, which is probably one of the reasons why they want to delay ending. But more specifically, plaintiff respectfully requests an extension of the discovery cutoff of 60 days, which would place the new discovery cutoff date on February 17th, 2026. With a proposed new deadline for dispositive motions of March 16th, 2026, and a pre-trial motions deadline of April 18th, 2026, with the current trial date of May 18th, 2026 remaining in place, unless the court finds a brief continuance of the trial date to be appropriate. There is no fucking world where if this got extended the discovery all the way to February, I don't believe that that the trial date would be extended. I'm going to kick it all down the road as much as possible. The active discovery period in this matter did not commence until the protective order governing discoveries issued, blah, blah, blah. This leaves on more than 3.5 months for the parties to conduct discovery under the current scheduling order. As of today, and further detailed below, the following discovery has not yet been completed. One, written discovery has been exchanged, but there are unresolved objections to defendant's document production. I have produced way more than she has, and I produce everything that's responsive to what she's asking for. The only stuff that they're still asking for is like retarded shit, like we need like Lycan's address, or we need cryptographic hash. Like if you want, I could just go generate a hash on all my text files. It's just the most retarded random shit in the universe. But there's like 7 or 8 outstanding things that There's like 7 or 8 outstanding things that we've requested that we have nothing of. I don't have any of Pixie's conversations with Aaron. I don't have any of her conversations with Lauren. I don't have any of her conversations that are super responsive to any, like all of the people that we've found for subpoenaing are people that we've had to find on our own. She didn't disclose any of them initially, and they tried to throw roadblocks to us subpoenaing or doing depositions for anybody that would, well, I mean, maybe would they help her case? Who knows? We haven't deposed them yet. The depositions of plaintiff and defendant have not been rescheduled despite plaintiff's good faith effort to do so. So the thing that scares me about this, about trying to move back the dates here, is that this argument is decently strong, and generally, like, we're going to fight the motion, but like generally speaking, you have to depose the parties to the case. So because the judge hasn't ruled on our protective order, and because neither party, so me nor Pixie, have been deposed yet, I feel like the judge will extend the discovery. I guess I'm hoping maybe it'll only be a month instead of 2 months. I don't know, but like we haven't done anything. So is that allowed? If it is, why don't you do it too? Why don't I do what? There's nothing for me to do. I don't have anything to hide. Like I don't need to do anything like that. I don't need to. And also, technically, all the depositions they've done have just been incredibly helpful to me. Their deposition of Rose, which they thought was going to be this slam dunk fucking crazy thing, ended up biting them in the ass hardcore halfway through that fucking deposition. They realized they were completely totally fucked. So no, I don't have anything to fucking hide on this shit. Like all my shit is leaked to the public, is out in the open, is whatever anyway. Like the only people who shit to hide right now are Lauren, who is apparently stalking, harassing me fucking publicly when I visit other states, and then fucking Pixie, who likes to just close her eyes like the retarded dipshit she is, and pretend that none of this is even happening, while she, you know, travels around to Miami and hangs out with her fake fucking wife and posts these fucking videos on TikTok or whatever, and then, you know, does her 7 years of law school in Illinois or however the fuck long it's going to take her to get her 4th degree. The deposition of non-party witness Melina Jurensen has not yet been scheduled. I don't even know what they could possibly hope to talk to her about, but okay. Furthermore, while plaintiff diligently sought and participated in the discovery since the issuance of the protective order, defendant's production of documents has been demonstrably deficient and tardy. Plaintiff engaged in a meet and confer with defense counsel, which resulted in supplemental productions of documents, including the most recent production on November 25th, but plaintiff contends that the production is still deficient and thus anticipates filing a motion to compel. Yeah, we'll see. The last stuff, I should say, the last stuff that they tried to ask for was, I think they were saying, like, we need all your recent conversations with, like, food shops and Zip or whatever. And it's like, excuse me, I'm sorry, you stupid fuck. You don't get to just, like, mine all my random personal conversations because you're fucking bored and you're some loser who has nothing to do with their life but read through my Discord logs. Like, eat shit, kick rocks. Like, get the fuck out of here. It's so stupid. The last 3, and there were, like, 3 or 4 random Discord people like, we would need all your recent conversations. Shut the fuck up. The fuck out of here. Give me a single conversation that's actually responsive to what we've asked for. And but plaintiff will also require adequate time to investigate her forensic expert's findings of potential spoliation and tampering of evidence by defendant. Well, how much more time do you fucking need to sit there and read some guy who's tech illiterate, who filed a bullshit SIR reply to retract 2 paragraphs of his quote-unquote expert witness testimony like the day after he fucking filed it? Give me a fucking break. Which plaintiff could not have anticipated. In view of the incomplete discovery and the looming discovery cutoff date, plaintiff's counsel proposed the parties file a joint motion to extend the deadlines and suggested dates for the depositions of plaintiff and defendant in Miami during the same week in early January. Oh, so now you can schedule it in the same week? Oh, I thought before that was impossible. But if it's going to be past the December deadline, oh, now all of a sudden you're willing to do it. Good one. Good one. See Exhibit V, or Exhibit B. Defendant's refusal to agree to a reasonable modification of certain deadlines smacks of bad faith and gamesmanship and an ulterior motive to prevent the defendant's deposition from taking place. Even the moderate request for 60-day continuance plaintiff proposed would make it difficult to allow the parties to reasonably conduct discovery and resolve any discovery disputes, given that it would set an active discovery period spanning less than 6 months. It would be highly prejudicial to plaintiff to be unable to take the deposition of defendant or complete other discovery in this matter, or to routinely extend discovery, blah, blah, blah. Relevant factual background. That's just the case. Plaintiff diligently conducted and participated in a discovery. That's a fucking lie. None of the earlier things that I said. Destiny, how does she benefit from pushing the deadline back? Because her case is a loser, and she knew it before she filed the fucking case. So she doesn't want to go to trial. Or maybe she does, but whatever she wants to do, the only thing that damages me is however long this goes on for. The last thing that Pixie wants is the case to be dismissed, for me to win on the motion for summary judgment, or for me to win at trial. She wouldn't care if I win at trial because that case has gone on for as long as possible. The only thing she has left is to shitpost whatever stuff the mentally retarded Joan is willing to throw in whatever fucking court filing that ChatGPT is willing to write for her. And that's it. That's all she has. So the longer they can keep it going, the more motion practice that she can do. I'm glad that Joan found a new map to grind her motion writing skills in, and has probably leveled up 400 fucking times, writing more motions than every fucking than every attorney in the state of fucking Florida for the past, I don't know. When is discovery over? Discovery was supposed to end in a week and a half. They wanted to go on for another 2 months. What happens after discovery ends? Well, after discovery ends, you can file for your motion for summary judgment. So right now we have an outstanding, there's a lot of outstanding stuff. Right now we have an outstanding motion to dismiss, saying the court doesn't even have the subject matter jurisdiction to hear this case, because they don't even have any allegedly bad behavior that is even in the time frame of like this, of when the law was even written. The chances of winning on that, I thought were low, but they might be higher than I thought. But after discovery ends, you can file a motion for summary judgment. Motion for summary judgment is where the judges are allowed to look at all the data, not all the data, is allowed to look at all the evidence and like a more determinative thing based on what's actually in the record. The motion for summary judgment is where I plan on winning. The only way, it would be really surprising if I didn't win on that. But after discovery ends, that motion for summary judgment can be filed, but with discovery still ongoing, there's no way you can file an MSJ. I mean, you could, but it would be retarded because the judge is more likely to refuse it because you guys haven't finished discovery yet. What the fuck? And I believe you only get one shot at a motion for summary judgment. This is just random excuses that her lawyer's writing for her. We would have sat for these depositions months ago if they hadn't dragged their fucking feet on all the fucking filings and dragged their feet on scheduling anything. Do you have any background info on why this young person hates you or fucking guts or what's her problem? I don't know. Like I said, my guess is a family friend. She's an immigration lawyer from Puerto Rico who is appearing pro vice for this case. My guess is she's just a family friend. How many people are maliciously participating on the legal side of this? On the legal side, I mean, it's just her lawyers. Lauren De Laguna herself has contacted at least 9 people where she's reaching out to people to make videos on me. She gave Amy Dangerfield. You remember how she randomly made a video about the court case? It was because Lauren was giving her guidance on that. Lauren spoke to Abba. She spoke to Irrelevant. She emailed Hassan and Ethan to try to hop on their shit. She